The seller of a 1 to 4 unit residential property needs to complete and deliver to a prospective buyer a statutory form called a Transfer Disclosure Statement, or TDS. More generically, you may hear it referred to as a Condition of Property Disclosure Statement. The seller's mandated use of TDS requires it to be prepared with honesty and in good faith, whether or not a seller's agent is retained to review its content. When preparing the TDS, the seller sets forth any property defects known or suspected to exist by the seller, any conditions known to the seller which might negatively affect the value and desirability of the property for a prospective buyer are to be disclosed, even though they may not be an item listed on the TDS. Further, disclosures to the buyer are not limited to conditions pre-printed for comment on the form. Also, the buyer cannot waive delivery of the statutorily mandated TDS. Any attempted waiver, such as a as-is provision in the purchase agreement, is void as against public policy. Transactions which exempt the seller from preparing and delivering the statutory TDS to the buyer include transfers by court order, such as probate, eminent domain, or bankruptcy, by judicial foreclosure or trustee sale, on the resale of REO or real estate-owned properties acquired by a lender on a deed in lieu of foreclosure or by foreclosure, from co-owner to co-owner, from parent to child, from spouse to spouse, including property settlements resulting from a dissolution of marriage, by tax sale, by reversion of unclaimed property to the state, and from or to any government agency.